The engineer's truck sat parked at the top of the ridge for 11 minutes before Dale Merritt walked out to meet it, and he counted every one of those minutes standing at his own kitchen window, watching a stranger in a hard hat walk slow circles around a stretch of pasture that had never, in 31 years, needed anyone's permission but his to be crossed. The man was measuring something. Dale could see that much from the window. A tripod-mounted instrument, a clipboard, the particular unhurried confidence of someone who believed he had every right to be standing exactly where he was standing. Behind him, further down the ridge, two more trucks idled at the gate Dale had built with his own hands the summer his daughter was born. The gate that had never once, in 3 decades, needed a stranger's truck idling in front of it. Dale had leased that ridge and the 400 acres running north of it from Harlan Voss for so long that most of the county had simply stopped thinking of it as anyone's land but his. The way people forget a rented house isn't the same as an owned one until the day something reminds them. He'd run cattle on that ground since he was 26 years old, had learned every low spot where water pooled after a hard rain and every high spot where the grass came in thin no matter how much rain fell, had built 2 water tanks and 3 miles of fence line at his own expense over the years because Harlan Voss had never once asked him to and never once needed to. The arrangement between them settled so long ago and so completely that neither man could have told you, if you'd asked, the exact year the handshake had happened. What Dale didn't know yet, standing at that window watching a stranger measure his pasture with an instrument he didn't recognize, was that the ground beneath his boots had never actually been his to lose in the first place. Not really, not in the way that mattered now. Harlan Voss had sold the mineral rights to that whole stretch of ridge back in 1961, decades before Dale had ever set foot on the property, to a small independent operator that had drilled 1 dry hole that same year and simply walked away, filing the lease paperwork in the Coke County Records Office and letting it sit forgotten for the better part of 6 decades, changing hands twice more through corporate acquisitions nobody in the county had ever noticed or cared about, until it finally landed, 3 years earlier, in the portfolio of a mid-sized operator out of Midland called Kestrel Basin Resources. The engineer finished his measurements, folded his tripod, and drove away without ever once approaching the house. If this story is finding you somewhere tonight, we'd genuinely love to know where. Drop it in the comments. Tell us what part of the country or the world you're watching from. And if a story like this one is worth passing along, share it with somebody who'd appreciate it. And also make sure you subscribe so you don't miss any video from us. Now, back to Dale and to a fight that was only just getting started. Dale went back to his coffee, already cold, and told himself it was probably a survey crew checking something for the county. A water table study, a soil assessment, something that had nothing at all to do with him. He almost believed it. He kept almost believing it for the 3 days it took a certified letter to arrive from an address in Midland he didn't recognize, addressed not to him but to Harlan Voss, forwarded to Dale's mailbox with a yellow sticky note in Harlan's shaking handwriting that said only, "Dale, you need to see this before I do anything." He read it standing at the same kitchen window, morning light falling across paper that used words like surface use agreement and directional drilling program and estimated recoverable reserves, words that meant, once Dale worked through them slowly enough to understand what they actually added up to, that Kestrel Basin Resources intended to drill a well on the exact section of ridge where his primary water tank sat, the tank that fed nearly 200 head of cattle through the driest months of a Texas summer, the tank he'd built himself with money he'd saved for 3 years to afford, on ground he at leased and worked and improved for 30 decades without ever once being told by anyone that the dirt beneath it had already belonged to someone else since before he was even born. He sat down at his own kitchen table, the letter still in his hand, and understood with the particular clarity that comes from finally seeing something you should have understood all along, that everything he'd built on that ridge had always rested on a kind of ownership that never actually existed, not in any form the law would recognize, and that whatever happened next was going to depend entirely on facts he'd never once had reason to learn. Coke County sat in the rolling mesquite and caliche country of west central Texas, the kind of ground that had supported cattle ranching for more than a century, and in scattered pockets across the region, oil and gas production for nearly as long. the two industries existing side by side across the same land in a relationship most people outside the state understood poorly and most people inside it understood mainly through hard experience. Dale Merritt was 57 years old that spring, broad through the shoulders in the particular way of a man who'd spent his whole working life on horseback and in a saddle rather than behind a desk. His face weathered dark from decades of West Texas sun, a permanent squint lining the corners of his eyes from years of scanning open pasture for cattle, for weather, for the small signs of trouble a good rancher learned to read before trouble ever fully arrived. He'd grown up 2 counties over, the son of a man who'd worked as a hired hand his whole life without ever managing to save enough to lease ground of his own. And Dale had understood from an early age that the difference between a hand and a rancher in that part of Texas came down almost entirely to whether a man could find land to work that didn't demand more up front than he had. He'd found Harlan Voss's Ridge at 26, a young man 3 years into marriage with a baby daughter and a small herd of cattle he'd built up slowly from nothing, looking for grazing ground at a price he could actually afford. Harlan, even then well into his 60s, had inherited the 400 acres from his own father and had never run cattle on it himself, having built a modest career instead as an insurance adjuster in San Angelo, the ridge sitting mostly idle except for the deer season he leased out to hunters every fall. "You want to run cattle on it? Run cattle on it," Harlan had told him that first meeting, sitting on the tailgate of his truck at the property's edge. "I don't need the money bad enough to nickel and dime you over it. You take care of the ground, keep the fences up, and we'll figure a fair number between us every year. I don't need it in writing. A man's word is either good or it isn't, and I'll know which one you are inside of a season." They'd shaken hands on it that afternoon, and the arrangement had held, essentially unchanged, for 31 years. Dale paid Harlan a modest annual lease, adjusted upward maybe 6 times over 3 decades, and always by mutual agreement rather than demand. And in exchange, he'd built, at his own expense and with his own labor, 2 earthen stock tanks, 3 miles of new fence line, a set of working pens near the old loading chute, and a network of cross-fencing that let him rotate his herd across the ridge in a pattern that had, over the years, actually improved the grass rather than wearing it down the way overgrazing eventually wore down every piece of ground it touched. Have you ever built something with your own hands on ground that was never fully yours, and trusted without ever quite examining the trust itself that the person who did own it would always see things the way you did? Dale had never once in 31 years considered that question directly. He'd simply worked the way his own father had worked for other men his whole life. Except Dale had understood himself to be doing something meaningfully different, building equity of a kind, even if that equity lived in improved grass and standing water and fence line rather than in a deed with his own name printed on it. What neither Dale nor, for that matter, Harlan Voss himself had ever fully reckoned with was a much older transaction, one that predated Dale's arrival on that ridge by nearly 2 decades. In 1961, Harlan's father, facing a bad drought year and a genuine need for cash, sold the mineral estate beneath the entire 400 acres to a small independent oil company for $1,100, a sum that seemed at the time like reasonable money for rights to minerals nobody expected to ever actually matter, since the one well that company drilled that same year came up entirely dry, and the operation abandoned the ground within the year, filing the necessary paperwork and simply walking away. It's worth understanding something specific about how mineral rights actually work in Texas, since this single legal fact would end up shaping nearly everything that followed. When a mineral estate is sold or reserved separately from the surface land itself, a legal event called severance, Texas law treats the mineral estate as the dominant estate, meaning the owner of the minerals generally holds the legal right to use as much of the surface as is reasonably necessary to explore for and produce those minerals, even over the surface owner's objection, and even when the surface is actively being used for something else entirely, like cattle ranching. This doesn't mean a mineral owner can do absolutely anything they want to the surface. Texas courts have developed real limits over decades of case law, but the starting legal position, the default a surface owner has to overcome, favors the mineral owner's right of access, not the surface owner's right to be left alone. Harlan Voss had inherited the surface estate from his father decades later, with no idea, or at least no meaningful understanding, that the mineral rights beneath his own ground had been permanently separated from it, since nothing about owning and living on a piece of land day to day ever forced him to think about who owned what lay beneath his boots. He leased the surface to Dale in good faith, believing himself to be the sole owner of everything the arrangement implied, because in every practical sense that had mattered for 31 years, he had been. Kestrel Basin Resources had acquired that decades-old mineral lease 3 years earlier as part of a larger portfolio purchase, one of several thousand old, mostly forgotten mineral interests scattered across West Texas that the company's land department had spent months methodically reviewing for renewed potential, using modern seismic and drilling technology that made formations once considered uneconomical, including whatever sat beneath Harlan Voss's ridge, newly worth pursuing. Preston Coyle, the landman assigned to that section of Coke County, had been doing exactly this kind of work for Kestrel Basin for 6 years, tracking down mineral owners, negotiating surface use agreements, coordinating the survey and engineering work that preceded any actual drilling. He was 38 years old, methodical, and unfailingly polite in the particular way of a man who learned early in his career that politeness closed more deals than pressure ever did, and he genuinely did not think of himself as anyone's adversary. He thought of himself as someone doing a straightforward job, following processes his company's legal department had refined over decades of operating across mineral estates just like this one, processes that were, strictly speaking, entirely lawful. Preston had reviewed the file on the Voss mineral estate for the better part of a week before ever making contact, confirming the chain of title back to the original 1961 severance, running the geological data from a nearby producing well that suggested the same formation likely extended beneath the Voss ridge at commercially viable depth, and drafting the initial surface use proposal that would eventually reach Harlan Voss's mailbox as a certified letter. He had not, in that week of careful preparation, given any particular thought to who might actually be running cattle on that surface, since surface use agreements in his experience were negotiated with landowners, not tenants, and Kestrel Basin's own title research had confirmed Harlan Voss as sole owner of record. The existence of a 31-year handshake lease with a rancher named Dale Merritt simply hadn't appeared anywhere in the company's records because it had never needed to be recorded anywhere at all. Harlan Voss was 81 years old that spring, a widower for the past 6 years, living alone in the same modest San Angelo house he and his late wife had bought decades earlier, still driving out to the ridge himself every few weeks, mostly out of habit, to sit on the same tailgate where he'd once shaken hands with a 26-year-old Dale Merritt and watch from a comfortable distance cattle that were never his own, grazing ground that technically still was. He called Dale the same evening the letter's arrival note went out, his voice carrying the particular unsteadiness Dale had noticed creeping into it more often over the past year or two, a man genuinely uncertain for the first time in a long friendship of exactly what he was supposed to do next. "I didn't know," Harlan told him, and Dale believed him completely, having known the man 30 decades without ever once catching him in a lie worth mentioning. "My daddy sold that years before I ever took the place over. I don't think I even knew to ask about it when he passed it to me. Nobody explained to me that the ground and whatever's under the ground could belong to 2 different people entirely." "Neither did I," Dale said. "I don't want this," Harlan said. "I want you to know that plain before anything else gets said between us. I never leased you that ground thinking some company was going to show up 30 years later and start putting a well where your water tank sits. If there was something I could do to just tell them no, I'd do it in a heartbeat." "Can you?" Dale asked, though he suspected, even asking it, what the honest answer would be. Harlan was quiet a long moment on the other end of the line. "I don't rightly know," he admitted finally. "I never had cause to learn any of this before now." Neither, in truth, had Dale. Though he understood, sitting at his kitchen table with Kestrel Dayson's letter still spread out in front of him, that whatever happened to that section of ridge was going to determine, in very concrete terms, whether he still had a working cattle operation by the following spring. Dale drove into San Angelo 3 days later to meet with a lawyer, a decision that felt, pulling into the parking lot outside a modest office on Königheim Street, an admission he wasn't entirely ready to make, that whatever this was had already moved past anything he could handle with a phone call and a handshake, the way he'd handled nearly everything else in 31 years of ranching. Renata Ibarra, 44 years old, a native of the region who'd built a real oil and gas practice over 15 years, specifically because, as she told Dale within the first 10 minutes of their meeting, half the county needed exactly this kind of help sooner or later, and almost nobody understood the law well enough to ask for it before a certified letter forced the question. "I want to be straight with you from the start," she said, spreading Kestrel Basin's proposal across her desk alongside the property's original 1961 severance deed, which she'd pulled from the county records the same afternoon Dale called her office. "Texas law is not built to protect you here. The mineral estate is dominant. That means Kestrel Basin has a real legal right to access this surface to develop those minerals, and neither you nor Mr. Voss can simply refuse them outright. If this were a straightforward case, I'd be telling you to prepare for a well pad on your water tank and start planning where you're going to get your cattle drinking water instead." "But it's not straightforward," Dale said, hearing something in the careful way she'd phrased that. "It might not be," Renata said. "Texas has developed something called the accommodation doctrine over the past several decades, through actual court decisions rather than statute, and it gives a surface owner, or in some circumstances, a tenant with a real, provable interest like yours, a narrow but genuine avenue to push back. The doctrine doesn't let you block development, but it does require the mineral operator to use an alternative method of accessing the minerals if a reasonable alternative exists that doesn't substantially increase their cost or burden, and if their proposed method would completely destroy an existing surface use for which there's no other reasonable option available to you." "What counts as a reasonable alternative?" Dale asked, though he suspected even asking it what the honest answer would be. "That's exactly where this case would actually get decided if it comes to that," Renata said. "The classic accommodation doctrine case involves a situation where the mineral owner has more than one practical way to reach the same formation, and one of those ways would leave the surface owner's existing use completely destroyed, while the other wouldn't. If Kestrel Basin can drill the exact same well from a different location, even if it costs them somewhat more, a court can require them to use that alternative instead of the one that wipes out your water source." She pulled a topographic map of the ridge from a folder and spread it across the desk between them. "The first thing we need to establish, concretely, is whether an alternative location genuinely exists, not whether you'd prefer one, whether it actually technically works to reach the same mineral formation without unreasonably burdening their operation. That's not something I can determine on my own. That's an engineering question, and it's going to need real expert analysis, not just your say-so or mine." It's worth understanding, at this point, exactly what makes accommodation doctrine cases succeed or fail in practice, since it shapes everything that came next for Dale. Texas courts applying this doctrine, going back to the foundational case decided by the Texas Supreme Court in 1971, have consistently required surface owners to prove two specific things with real evidence, not simply assert them. First, that the mineral operator's proposed method of surface use would completely preclude or substantially impair the existing surface use, not merely inconvenience it. Second, and this is the part that actually decides most cases, that there exists a reasonable, technically feasible alternative method of extracting the same minerals that would allow both uses to coexist. Courts have been notably unsympathetic to surface owners who show up with objections but no real alternative plan, since simply not wanting a well somewhere isn't a legal argument, only a preference. What tips a case is hard, specific, technical proof that the company could reasonably do it differently and still get exactly what they're after. "I need a petroleum engineer," Renata said, "someone who can review Kestrel Basin's geological data if we can get access to it, or generate independent analysis if we can't, and tell us honestly whether a directional well from a different surface location could reach the same formation. If the answer's no, I want to know that now, so we can start planning around a real loss instead of chasing a case that was never going to hold up. If the answer's yes, we build the strongest possible record around exactly why the alternative works and exactly why it doesn't meaningfully burden their operation." Dale left that first meeting with a referral to an independent petroleum engineer in Midland and a bill for services that made him wince, though considerably less than the cost of losing his primary water source and a third of his usable grazing ground outright. The engineer, a soft-spoken man in his 50s named Gordon Reyes, who'd spent 22 years working for major operators before going independent, drove out to the ridge himself the following week, walking the ground alongside Dale for the better part of a full day, asking questions that revealed, gradually, just how much specific, granular knowledge of that ridge lived only in Dale's head, rather than in any official record anywhere. "Where does this tank actually draw from?" Gordon asked, standing at the edge of the water tank Kestrel Basin's proposed well pad would sit directly on top of. "Is this spring-fed or purely runoff catchment?" "Spring-fed," Dale said. "There's a fracture in the cap rock about 40 feet down that keeps it flowing even in a bad drought year. I know because I had a well driller out here 20 years back trying to figure out why this particular spot held water when 3 other sites I tried on this ridge came up dry. He told me the whole story of that fracture, drew me a rough sketch of it even, since he found it interesting enough to explain." "Do you still have that sketch?" Dale did, folded into an old feed store ledger he'd kept in his truck's glove box for 2 decades without ever once thinking it might matter to anyone besides himself. Gordon studied the sketch for a long moment, then walked the ridge further, taking his own measurements, checking the topography against a geological survey map he'd pulled together from public records, correlating what Dale's old well driller had documented against the modern seismic data Kestrel Basin had used to justify their proposed well location in the first place. "Here's what I can tell you honestly," Gordon said, once he'd finished his survey late that afternoon, the two of them standing at the tailgate of Dale's truck, with the sun starting to lower over the ridge. "The formation they're targeting sits roughly 8,000 feet down, and it extends laterally under a significant portion of this whole ridge, not just the specific spot where they've proposed the pad. That's actually good news for you in a strange way. It means they don't need to be sitting directly on top of this water tank to reach it. A directional well, drilled from a surface location maybe 600 yards east of here, on that flatter stretch near your old loading pens, could reach the exact same target formation with a lateral run that's well within normal industry practice these days. It's more common than people realize. Companies do this specifically to avoid surface conflicts, when the alternative site doesn't cost them meaningfully more." "Would it cost them more?" "Some," Gordon said. "Directional drilling generally runs somewhat higher than a straight vertical well, purely on drilling time and complexity. But we're not talking about a difference that makes the well uneconomical. Based on what I know about typical costs for a lateral run of this distance, and what I understand about current gas prices and the size of the reserve they're likely targeting here, the additional cost would represent a small percentage of their total project budget. That's exactly the kind of gap the accommodation doctrine is built to address. If the burden on them is minor and the harm to you is total, the law leans your direction." Dale felt something in his chest ease for the first time since that certified letter had arrived, though Renata, when he called her that evening to relay Gordon's findings, was careful to temper his relief before it ran too far ahead of the actual legal process still in front of them. "This is a real, strong foundation. It's not a guaranteed win. Kestrel Basin has their own engineers, and they're going to push back hard on Gordon's cost estimates, probably arguing the difference is larger than he's calculating, or that the geology doesn't support a lateral run as clean as he's describing. We need to formalize everything he's found into a proper report, And we need to request Kestrel Basin's own geological and cost data through the surface-used negotiation process, so we're not just guessing at their numbers, we're directly comparing our analysis against theirs. The formal request for Kestrel Basin's geological and cost data went out under Renata's letterhead in early April, along with a written notice on Harlan Voss's behalf as the surface owner, and Dale joined as a party given his documented decades-long surface use interest, formally objecting to the proposed well location and requesting good faith negotiation toward an accommodated alternative before any drilling permit application moved forward. Preston Coyle called Renata's office within the week, his tone, by Renata's account afterward to Dale, genuinely more curious than hostile. The tone of a man encountering a level of organized pushback he didn't often see from ranchers in this part of the state. Most surface owners in your position don't have an independent engineer's report ready before we've even finished our own internal review, Preston told her, according to what Renata relayed. I'll be honest with you, that changes how seriously my company is going to take this conversation. I'm not authorized to agree to a location change on the spot, but I can tell you we'll review what you've submitted properly, rather than dismissing it. Kestrel Basin's own engineering team took nearly 6 weeks reviewing Gordon's report and running their own comparative analysis, a stretch of time that felt to Dale considerably longer than 6 weeks actually was, each morning bringing him out to check on the water tank and the cattle grazing near it with a kind of low, constant vigilance he hadn't carried in years, watching for survey trucks that, mercifully, didn't return during that whole waiting period. The response, when it finally came in mid-May, was not the outright rejection Dale had privately braced himself for, nor the full capitulation he'd allowed himself to hope for on his better days. Kestrel Basin's own engineers had confirmed that a directional well from the alternate location near the old loading pens was technically feasible and would reach the same target formation, but disputed Gordon's cost estimate, arguing the additional expense would run closer to 18% above the original proposed location rather than the roughly 6% Gordon had calculated, a difference substantial enough in Preston Coyle's formal letter to argue the alternative location represented an unreasonable burden rather than a minor one. This is where it actually gets decided, Renata told Dale, laying both cost analyses side by side across her desk. 18% versus 6% isn't a small gap. We need to understand exactly where that difference is coming from, because if their number is closer to correct, this case gets considerably weaker. If Gordon's number holds up under real scrutiny, we're in a strong position to either negotiate a favorable accommodation directly, or, if they still refuse, to take this in front of a judge with genuinely solid evidence behind us. Gordon spent the following 2 weeks working through Kestrel Basin's own submitted cost breakdown line by line and found, buried in their calculation, an assumption about rig mobilization costs that treated the alternate site as though it required an entirely separate access road build-out from scratch, when in fact, as Dale himself pointed out once Gordon walked him through the discrepancy, the old loading pen road, built and maintained by Dale himself for 3 decades, already provided adequate all-weather access to within a few hundred yards of the proposed alternate pad location, a fact that existed nowhere in Kestrel Basin's records because nobody on their survey team had ever actually driven that particular stretch of ranch road themselves. They built their whole cost differential assuming they'd need to construct a new road from the county highway, Gordon explained, spreading a corrected calculation across Renata's desk. Once you account for the existing access Dale's already maintained for years, that additional road building cost disappears almost entirely. Correct their number for that one assumption alone, and their 18% gap collapses to somewhere close to my original 6% estimate. Renata submitted the corrected cost analysis to Kestrel Basin's legal department in early June, along with a formal request for a face-to-face negotiation session rather than continuing to exchange letters through counsel, a move she explained to Dale as a deliberate attempt to get past the more defensive posture written correspondence tended to produce and into a room where actual engineers could talk to actual engineers without lawyers filtering every sentence first. Companies like Kestrel Basin aren't monoliths, Renata told him, driving out to the ridge together the week before the scheduled meeting, ostensibly to walk the proposed alternate site one more time before presenting it formally. Preston Coyle isn't the enemy here, not really, even though it's easy to think of him that way. He's a landman doing a job his company's legal and engineering departments define for him. If we can get their actual engineers looking honestly at Gordon's corrected numbers without the conversation being filtered entirely through a negotiating posture, there's a real chance this resolves without ever needing to go in front of a judge at all. And if it doesn't resolve that way? Then we file, Renata said simply, and we'd be filing from about as strong a position as I've seen in a case like this in 15 years of doing this work. But litigation is slow and it's expensive for everyone involved, including Kestrel Basin, and companies generally prefer a negotiated accommodation over a court fight they might lose, especially once their own numbers stop supporting their original position as cleanly as they did a few months ago. The meeting took place in mid-June at Kestrel Basin's regional office in Midland, a modest conference room on the third floor of a building Dale had driven past 100 times over the years, without ever once imagining he'd sit inside it fighting for the ground beneath his own water tank. Preston Coyle sat at one end of the table alongside two of Kestrel Basin's staff engineers, a woman named Diane O'Coffer, who led the company's regional development team, and a younger reservoir engineer named Marcus Webb, who'd been the one to originally run the cost comparison Gordon had since picked apart. Gordon walked the room through his corrected analysis methodically, laying out the original discrepancy in the road access assumption, the corrected cost differential, and a series of technical drawings showing the proposed directional well path from the alternate site reaching the same target formation with what he characterized, carefully, as a genuinely comparable extraction outcome to the original proposal. Marcus Webb, to his credit, didn't argue the point once he'd had a chance to review Gordon's corrected numbers against Kestrel Basin's own internal data. He's right about the road assumption, Marcus admitted, looking through the figures a second time as though hoping to find something Gordon had missed and coming up empty. We built that cost model off a generic access template our GIS team uses for undeveloped ranch land. Nobody flagged that this particular site already had established, maintained access. That's a real error on our end, and it does close most of the gap between our numbers. Renata O'Coffer, listening to this exchange with the particular careful neutrality of someone whose job depended on weighing genuine business considerations rather than personal sympathy, asked the question Dale understood, as she asked it, was the one that would actually decide everything. Setting aside the cost differential for a moment, she said, looking directly at Gordon rather than at Renata or Dale. Does the alternate location introduce any technical risk to well performance? A directional well isn't purely a cost question. A lateral run of this length isn't unusual for the Permian Basin generally, and I don't see anything in the geology specific to this location that would meaningfully increase mechanical risk. That's my honest professional assessment. I'm not going to tell you there's zero additional risk in any directional drilling program compared to a straight vertical well, because there never is. I'm telling you the incremental risk here is small and well within what your industry considers routine. Dale was quiet for a long moment, turning a pen over slowly between her fingers, the particular stillness of someone actually weighing a decision rather than performing the appearance of weighing one. I want my own team to review your seismic correlation before we commit to anything, she said finally. Not because I doubt your numbers on their face, Mr. Reyes. Your analysis is more rigorous than most independent reports I see in these situations. But this is a real operational decision on our end, and I owe it to my own engineers to have them confirm the well path independently before we agree to move a proposed location. That's entirely fair, Renata said. We're not asking you to take our word for it. We're asking for a genuine technical review of an alternative that our own analysis suggests works. If your team reaches a different conclusion, we'd want to understand specifically where and why, and we'd engage with that honestly rather than simply insisting on our position. It's worth pausing here on something that mattered enormously to how this negotiation actually unfolded, since it's easy to imagine legal disputes like this one as purely adversarial contests where one side simply outmaneuvers the other. In practice, accommodation doctrine negotiations that resolve successfully without ever reaching a courtroom generally do so because both sides have real mutual incentive to avoid litigation if a workable technical solution genuinely exists. Kestrel Basin had no interest in spending months and real legal fees defending a well location in court if an equally productive alternative existed at a comparable cost, since a court loss would set them up for the same fight on every other surface conflict across their broader portfolio of mineral leases. Dale and Harlan had no interest in a drawn-out legal battle either, given the expense and uncertainty of litigation even with a strong case. The accommodation doctrine, properly understood, wasn't really designed to produce winners and losers through combat. It was designed to force exactly this kind of genuine technical conversation, one that might never have happened at all if the law didn't give the surface interest enough real leverage to get a company's engineers into a room taking the question seriously in the first place. Kestrel Basin's internal engineering review took another 5 weeks, a stretch of time that felt to Dale considerably shorter than the previous 6-week wait had, if only because he now understood, with real specificity, exactly what was being evaluated and by whom, rather than simply waiting in the dark for an answer he had no way to predict. The formal response arrived in late July, not as a certified letter this time, but as a phone call from Preston Coyle directly to Renata's office, followed by written confirmation the same week. Kestrel Basin's engineering team had independently confirmed Gordon's seismic analysis and agreed that a directional well from the alternate location near the old loading pens could reach the target formation with acceptable technical risk and a cost differential the company's own recalculated figures now placed at just under 7% above the original proposal, close enough to Gordon's original estimate that further dispute over the exact number no longer seemed worth either side's time. Kestrel Basin agreed to relocate the proposed well pad to the alternate site. The formal surface use agreement, when it finally arrived for signature in August, ran to nearly 30 pages of provisions Dale would never have understood on his own, but that Renata walked him through carefully over the course of an afternoon, explaining each protection it built in beyond simply the relocated pad itself. The agreement specified restricted operational hours in calving season when heavy truck traffic and drilling noise could seriously stress a pregnant herd. It established a buffer zone around both of Dale's existing water tanks that prohibited any related infrastructure, including pipelines and access roads, without separate negotiated consent. It required Kestrel Basin to restore any temporarily disturbed surface to its prior grazing condition once active drilling concluded, with a bonded guarantee behind that promise rather than simply a good faith commitment. And it explicitly recognized, in writing for the first time in 31 years, Dale's status as the operating tenant with a documented, protectable surface interest in that section of the ridge, a formal acknowledgement that had never existed anywhere on paper before that summer, born entirely out of a fight neither he nor Harlan had ever wanted to have in the first place. Harlan Voss drove out to the ridge the day the agreement was finally signed, parking in his usual spot and walking, slower than he used to, but still walking that stretch of ground on his own 2 feet out to the old loading pens, where Kestrel Basin's survey crew had already begun marking the boundaries of the relocated well pad site. "Never thought I'd live long enough to need a lawyer over dirt I already thought I owned free and clear," he said, standing beside Dale at the fence line, watching the survey stakes go in at a location that would, within a few months, host a working well pad instead of the water tank it had originally been slated to destroy. "Neither did I," Dale said. "I keep thinking about my daddy," Harlan said after a while, "selling those minerals back in '61. He needed that $1,100 bad that year. I remember him saying so at the time, though I was too young to understand what it actually meant. I don't imagine he ever once considered that some company 60 years later would still be able to reach up out of a decision he made in a bad drought and touch ground he'd already handed off to me and that I'd already handed off to you." "Wasn't his fault," Dale said. "Wasn't yours either. Wasn't even really Kestrel Basin's fault when it comes down to it. That's just how the law's built out here. Whoever owns what's underneath gets to reach up and touch what's on top, mostly, unless somebody can prove there was a better way to do it that didn't cost anybody anything extra worth arguing over." "You proved it," Harlan said. "Gordon proved it," Dale said. "I just knew where the water actually came from." Have you ever spent decades building something on ground you understood in the back of your mind could technically be taken from you at any moment, and only fully reckoned with how much that arrangement had always rested on someone else's goodwill the day that goodwill finally got tested by something neither of you controlled? Dale thought about that question often in the months that followed, watching Kestrel Basin's crew build access to the relocated pad along the same ranch road he'd graded and maintained himself for 3 decades. watching the actual drilling operation move forward that autumn with a schedule and a set of restrictions that kept his cattle undisturbed through the calving season the following spring, exactly as the agreement had promised. The well came in productive that winter. Not spectacularly so by Kestrel Basin's own internal standards, but solidly enough that Preston Coyle mentioned during one of his periodic site visits that Dale had come, somewhat to his own surprise, to find himself not minding, that the company considered the whole project a genuine success, technically and financially, despite the modest additional cost the relocated site had required. For what it's worth, Preston told him, standing at the fence line one cold morning that January, watching a work crew finish up routine maintenance at the pad site well clear of Dale's water tank and grazing rotation, I've handled a lot of these surface conflicts over the years. Most ranchers I deal with either roll over because they don't know they have any options, or they dig in on pure principle without ever bringing anything concrete to the table. And either way, it usually ends about how you'd expect. What you and your lawyer did here, bringing an actual engineer, actual numbers, actual proof there was a better way to do this that didn't cost my company anything unreasonable, that's rare. I respect it, even though it made my job considerably harder for about 4 months. Wasn't personal, Dale said. Wasn't for me either, Preston said. Never is most days. Just happened this time that the facts actually supported you instead of us, and you were smart enough to find that out and prove it before we ever got a permit filed. By the following spring, the relocated well pad had settled into the kind of quiet, routine operation that eventually made most working oil and gas sites on ranch land nearly invisible to daily life. A fenced installation off in the distance that Dale's cattle grazed around without much concern. The water tank and the calving pasture it protected still exactly where they'd always been, still exactly as productive as they ever had been. 31 years of work still standing on ground that had very nearly been pulled out from under him entirely by a decision made in a drought year 6 decades before he was even born. Harlan Voss passed away 2 years later, peacefully, in his sleep at 83, and left the ridge itself, along with what remained of the mineral royalty payments that had begun arriving from the productive well, to his 2 adult children, neither of whom had ever shown much interest in ranching or in Coke County generally. Dale had genuinely expected, in the uncertain weeks following Harlan's death, that this transition might finally be the thing that ended his 33-year lease, that a new generation of owners with no memory of a handshake made on a truck's tailgate decades earlier would simply choose to sell the whole property outright, mineral royalties and all, to whoever offered the best price. Instead, Harlan's daughter, a woman named Carol Voss Reyes, who lived in Austin and visited the ridge perhaps a dozen times in her entire adult life, called Dale directly within a month of the funeral, having found, going through her father's papers, not just the original 1961 severance deed, but the complete file Renata had built during the accommodation doctrine negotiation, 30 pages of surface agreement, Gordon's engineering reports, correspondence with Kestrel Basin spanning nearly 6 months of careful, documented work. My father kept all of this, Carol told him, when they finally spoke. He had it filed separately from everything else, in its own folder, like it mattered more to most of his other papers. I read through the whole thing before I called you. I understand now, in a way I don't think I ever really understood growing up, exactly what you actually built out there, and what it took to protect it when it mattered. She renewed his lease that same call, on terms essentially unchanged from the arrangement her father had honored 30 years, and added, almost as an afterthought before they hung up, that she intended to split the ongoing mineral royalty payments with him going forward, a 50-50 share neither the original handshake nor Texas law required of her in any way, offered simply because, as she put it, the well never would have come in where it did, productive and clear of the water her father's cattle tenant had spent 30 years protecting, if Dale wasn't the one standing on that ridge to fight for it in the first place.